thank you all for coming out. This is this information, this policy that we belatedly learned about last year is something that's very close to us, because another piece of the puzzle of the delay in getting Zahid citizenship has fallen into place. And I want you to try and get in your mind that throughout the media there's a demographic that's talked about, and they are termed illegal aliens, and that's not the demographic that I'm going to talk about tonight, because they're not in this policy. They're somewhere else. This policy is about the demographic that you don't hear about, because it's secret, it's illegal, it's immoral, it's unethical, and it's unconstitutional. And so it's very important that this information gets out, because it's a demographic that nobody hears about. So on my little invitation, I asked, are you NS? How about you? Are you NS? Are you NS? Does anybody have an idea what NS means? Hopefully in this presentation I will be able to clear that up. The name of this presentation is CARPP, C-A-R-R-P, Controlled Application Review and Resolution Program. And the subtitle of it is Muslims Need Not Apply. So our UNS, we'll find that out. Martin Niemöller, he's got his very famous poem. He was a Protestant pastor. First they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionist, and I did not speak out because I was not a trade unionist. And then they came for the Jews, and I did not speak out because I was not a Jew. And then they came for me, and I did not, and there was no one left to speak for me. Specialist Yassine Bamamu, to whom the Army promised expedited citizenship when he joined as an Arabic translator, but who instead endured years of delay to become a citizen after unfounded accusations were made against him and other Muslim soldiers. He said, I joined the Army to fight for other people's freedom, and I ended up losing my own. I always played by the rules. I paid taxes, I contributed to society, and raised a beautiful family. The U.S. government treated me differently in the citizenship process because I am a Muslim man. It was incredibly frustrating and truly demoralizing. No person of faith, no honest man or woman should have to face the discrimination I have, especially when striving to take an oath of allegiance to the United States. And that's Tariq Hamdi. Madi Aga Asghari. Part of the reason that people love to become United States citizens is because of the great features the great features of the U.S. Constitution and the U.S. system in general. Equality for everybody, and you expect that would be true in the process of becoming a U.S. citizen. But instead we are being treated in a way directly opposite because of our religion and national origin. I never expected the U.S. government, which is the most important preserver of the Constitution, would itself be violating it and doing it secretly so that most people cannot even know about it. That is hurtful, and it strikes me that it is un-American too. It shatters your belief to some extent in what America stands for. Millions of immigrants and aspiring Americans apply to U.S. Citizenship and Immigration Services, USCIS, each year for immigration rights, including to naturalize as American citizens, but under a previously unknown national security program. You got the NS? National Security Program. USCIS secretly excludes many of those aspiring Americans from Arab, Middle Eastern, Muslim, and South Asian communities. That's also referred to as AMEMSA communities. They delay and deny their applications without legal authority. For years and without notice to the applicants, to their lawyers, or the public at large, USCIS has been blacklisting law-abiding applicants as national security concerns. These aspiring Americans are barred from obtaining immigration benefits rights to which they are legally and statutorily eligible. As a result, by putting their applications on indefinite hold or rejecting them for unfounded reasons, thousands of law-abiding immigrants have had their dreams of citizenship and other immigration statuses dashed without ever being told while their applications were being treated differently than others. Approximately 2008, USCIS implemented this covert agency program known as the Controlled Application Review and Resolution Program, or CARPP, to ensure that immigration rights are not granted to individuals and organizations that pose a threat to national security. But the program relies on deeply flawed mechanisms to identify, quote, national security concerns, end quote, including error-ridden and overbroad watch list systems and security checks and religious, national origin, and associational profiling. Predictably, the CARPP program not only catches far too many harmless applicants in its net, but it has overwhelmingly affected applicants who are Muslim or perceived to be Muslim or perceived to be from countries or areas that are predominantly perceived to be Muslim. The CARPP program directs agency officers to delay and ultimately deny the immigration application, two applications it has blacklisted, all without ever telling these individuals that they were labeled threats to our nation, let alone giving them an opportunity to respond to the allegations. USCIS paints a picture of a government that welcomes some but shuns others based on their religion, national origin, and other profiling criteria, and that secretly deprives those it blacklists of the rights afforded them by law. Findings. It misidentifies, quote, national security concerns, end quote. CARPP disproportionately impacts immigrants from Arab, Middle Eastern, Muslim, and South Asian communities. It does so by relying on extraordinarily overbroad criteria that treats religious practices, national origin, and innocuous associations and activities as, quote, national security concerns, end quote. And through reliance on a faulty watch list system and FBI surveillance, and that it can include other agencies as well, data that sweeps in people who do not present any actual threat. CARPP broadly defines a, quote, national security concern, end quote, as an individual with, quote, linked to prior, current, or planned involvement in or association with an activity, individual, or organization described in the Security and Terrorism sections of the Immigration and Nationality Act, end quote. But then further expands the breadth and vagueness of that definition by explicitly instructing officers to ignore the legal standards of proof set forth in those sections of that same act. CARPP automatically deems applicants whose names appear on the terrorist watch list as, quote, national security concerns, end quote, thereby imposing an even more severe harm than the travel-related harms normally associated with inclusion on the watch list. Under CARPP, USCIS will delay and likely deny the application of an individual labeled a, quote, national security concern, end quote. The terrorist watch list is a faulty, over-inclusive list containing hundreds of thousands of names of individuals, including U.S. residents, who are never told they are on the watch list and never given a meaningful opportunity to dispute their inclusion on it, or any meaningful way to get off that list. CARPP creates new secret eligibility criteria for immigration rights by the preventing of the approval of any application for an immigration right that the agency labels a, quote, national security concern. CARPP instructs officers to label applicants, quote, national security concerns, end quote, based on national origin and other overbroad criteria, such as if they have traveled through or resided in areas of known terrorist activity, effectively singling applicants out as, quote unquote, concerns based on the country they are from, or if they wire money back to their families in their home countries, or if they speak a foreign language or have certain professions. CARPP instructs officers to label applicants, quote unquote, national security concerns if their names are contained in an FBI file related to a national security investigation, even if they were not the subject of the investigation, and even if, for example, their names appear in the file only because they attended a mosque that the FBI subjected to surveillance, or they once gave a voluntary interview to the FBI, as many Muslim immigrants have in the last decade. CARPP authorizes inordinate delays. CARPP mandates that USCI officers delay adjudication of applications in direct contravention of statutory time limits and limitations. It provides that USCIS may hold cases in abeyance for periods of 180 days to provide for investigation of the, quote, national security concern, end quote, whether by the FBI or USCIS, and that the field office director may extend those abeyance periods indefinitely, so long as the investigation remains open. Because CARPP prohibits an applicant considered a national security concern from being approved for it, even if they are statutorily eligible, it requires USCIS officers to delay adjudication until or unless they can find a reason to deny the application or otherwise decide that the quote-unquote concern has been resolved. CARPP encourages FBI interference and harassment. CARPP effectively turns over the immigration application process to the FBI, allowing them, the FBI, to dictate to USCIS when or whether an application should be granted, denied, or held in abeyance. It also provides the FBI an opportunity to comment on USCIS's proposed decisions in immigration cases, to submit questions for USCIS to ask in interviews, and to suggest requests for evidence that USCIS should make. So this means that the FBI is really essentially commenting directly to USCIS officers about what they're supposed to do in the adjudication process, and it kind of controls where it's going. The FBI controls what the USCIS is doing with an applicant. And the request for evidence is the USCIS will send out a letter to an applicant requesting some sort of evidence. And if they have their own criteria that they want to send out. The FBI will also say, well, okay, ask them for this, and ask them for this, and ask them for this, or ask them about this. CARPP requires USCI officers to inform the FBI or other relevant law enforcement agencies as soon as an applicant it has labeled a national security concern has applied for immigration. As a result, far too often the FBI exploits this information to blackmail applicants to work for them as informants, telling applicants that the FBI can help get their long-delayed immigration application adjudicated and approved if they agree to snitch on their communities. And we'll see a couple of people here in this process that were asked by the FBI to do that. CARPP mandates pretextual denials. CARPP creates new secret eligibility criteria for immigration by preventing the approval of any application for an immigration benefit that the agency labels a, quote, national security concern, end quote. USCIS is not authorized to make rules beyond those set forth by Congress for granting it naturalization or other immigration benefits. CARPP prohibits USCIS officers from approving any application for immigration belonging to a person whose name appears on the terrorist watch list. CARPP also prohibits USCIS officers from approving any application belonging to a person it deems a, quote, national security concern, end quote, for any other reason unless they have supervisory approval. CARPP mandates that USCIS find a pretextual statutory basis to deny any application blacklisted as a, quote, national security concern, end quote, even where the applicant is statutorily eligible. Such denials are often facially implausible or otherwise unfounded. As a result of CARPP's requirement that officers invent a reason to deny otherwise eligible applicants, USCIS often misuses the false testimony grounds as a basis to deny naturalization applications. CARPP deprives applicants of any fair process. Under CARPP, USCIS will neither tell applicants that they have been deemed a national security concern, nor give them an opportunity to contest that designation. So here you are waiting and waiting and waiting, and you don't know why you're waiting. You have no idea, even if you inquire, as we will hear from several folks in this presentation, they keep inquiring and they keep being told, well, it's just going through security checks. It's just going through security checks. And they're not told why, what's going on. USCIS violates constitutional due process protections and its own regulations by relying on derogatory information that creates the alleged, quote, national security concern, end quote, in deciding to deny an application and never disclosing that information or allowing the applicant to confront it. So investigations of immigration benefits applications must be conducted expeditiously, this is what the law says, with a general practice of adjudicating them within 6 months. Keep that in mind, about 6 months. Decisions to deny an application must be made based on statutory criteria, not secret policy. USCIS should not permit the FBI to use information about a pending immigration application to coerce or blackmail an applicant into serving as an informant. At a minimum, any discussion between the FBI and an applicant in connection with an immigration application must be knowing and voluntary. And USCIS must make clear that an applicant's eligibility for an immigration right is not contingent upon the cooperation with the FBI. USCIS should not permit the FBI to use the immigration application process to obtain information about individuals that does not pertain to USCIS's adjudication of the application. So here's Lady Liberty. We all revere her. The book of CARPP, you might notice, is in her hands here, in her hand, in her left hand. And liberty is bound with the red tape of discrimination. At the top left here, this is Tariq Hamdi. I'm going to take this out for this moment here. Okay, maybe I'm not. After the agency delayed adjudicating his case for years and denied it 3 times, based on, among other things, his alleged affiliation with BIF, that's a foundation that would help other people in floods and that type of thing. Tariq took his case to court in hopes of a fair decision on his application. In February 2012, after a 3-day trial, a federal district court judge rejected all of USCIS's pretextual claims for why Tariq was ineligible to naturalize. And the judge personally swore him in as an American citizen a few months later. Hassan down here in February 2009, Hassan passed his naturalization exam and interview, but 3 months later, USCIS called him in for a secondary interview. And this might be called a ruse secondary interview. An FBI agent attended that second USCIS interview and asked Hassan a series of questions about his community, his mosque, and Mr. Musavi, the imam. About 1 month later, the same FBI agent called him for a meeting and told Hassan that he would expedite his naturalization case if Hassan agreed to work with the agency, the FBI, as an informant. Although Hassan continued to receive calls from the agent, the FBI agent, Hassan declined the invitation to become an informant upon legal advice that his eligibility for naturalization could not be made contingent on his agreement to snitch on his community. This is Mahdi Asghari, an Iranian and practicing Muslim. He's waited for 3 years for a decision on his naturalization application. He is a Cornell University and Oklahoma State University mathematics professor who came to the United States in 1994 to pursue his PhD. After completing his PhD at Purdue University, USCIS granted Mahdi a national interest waiver, allowing him to adjust his status to that of a lawful permanent resident in recognition of his unique specialization in the field of mathematics, a unique specialization. USCIS also found it in the, quote, national interest, unquote, for him to remain in the United States. So they found it, he was a national interest to stay in the United States. He and his wife have since made the United States their home and are raising their daughter here. After submitting his application for naturalization in August 2010, Mahdi began receiving visits from the FBI agents in connection with his application. One agent told Mahdi's lawyer that the visits were just fishing expeditions, and to talk to him about Iran. But during one interview, the FBI agent's questions focused on his relationship with a fellow Iranian graduate student at Purdue University, where Mahdi had studied for his PhD, who is now the other graduate student, is on the specialty designated nationals list of the Office of Foreign Assets Control. During Mahdi's naturalization interview, a USCIS officer also asked him about his relationship with the same individual. Mahdi explained to the USCIS officer, as he did to the FBI, that the man was a former acquaintance and peer from graduate school with whom he had since had very little contact, except for occasional holiday greeting emails. By law, Mahdi should have received a decision on his application more than 2.5 years ago. But USCIS has placed his application on a CARPP processing track. Being placed on the CARPP track means endless delay and eventually a denial. Mahdi is anything but a national security concern, but so long as USCIS treats him as such under CARPP, USCIS will follow directions from the FBI and delay and ultimately deny his application. Remember up above it said that they found him to be, it was in the national interest for him to remain in the U.S. Uncovering CARPP. Tarek, Mahdi, and Hassan's stories are not unique. They are like those of an untold number of AMEMSA immigrants, that's Arab, Middle Eastern, Muslim, South Asian immigrants, and aspiring citizens whose applications for naturalization, lawful permanent residence, asylum, and visas have been unfairly delayed and denied on pretextual grounds. In spite of their legal eligibility for the benefits they seek since 2008, at least they're admitting it's 2008, but we believe it's much sooner than that, USCIS has used CARPP to quietly deny, without legal authority, the benefits to which the individuals are entitled. USCIS's attempts to detect, quote, national security concerns, end quote, among applicants for immigration benefits rely on a dragnet approach that treats lawful religious activity, national origin, and innocuous associations, remember the other fellow who was just somebody else who went to school with, as reason to label people as national security concerns. Moreover, under CARPP, USCIS takes its cues from the FBI, converting the immigration system into an instrument of law enforcement, but without any accountability. Congress long ago sought to eradicate discrimination from our naturalization system by passing the Immigration and Nationality Act of 1952. But since 2008, USCIS has effectively resurrected this discrimination under the cover of CARPP. Through CARPP, USCIS has established its own undisclosed set of criteria that do not relate to statutory eligibility, but nonetheless delay and exclude certain applicants from attaining benefits without congressional approval. Although USCIS has used CARPP to delay and deny immigration benefit applications for years, causing great harm to applicants and their communities, as well as considerable confusion for immigration lawyers, it was not publicly known until recently what was causing these problems. Through this report, we seek to publicly reveal this policy for the first time and explain how it operates to harm law-abiding aspiring Americans from AMEMSA communities. So since September 11, 2001, the federal government has made efforts to improve security screenings in every aspect of government. In the realm of immigration, the Department of Homeland Security, which was not in existence until September 2001, has sought to ensure not only that it thoroughly vets the immigration applications and petitions of those who seek to live in this country, but that its screening is done in coordination with other federal agencies, particularly law enforcement agencies, most especially the FBI. While USCIS policies and procedures to improve security screenings have changed and evolved since 9/11, these changes have sometimes brought with them administrative and legal problems for the agency and in turn, most definitely for the applicants. One significant problem resulted from the adoption of a new rule in November 2002 that requires the agency to run all applications for immigration through an additional security check known as the FBI name check. Infamous FBI name check. Zahed was on it for years, probably still is on it, for all we know. We kept calling and calling and calling. Oh, it's in the name check. It's in the name check. It's in the name check. Those checks, however, would search only FBI main files for records of individual applicants. After 2002, the FBI name check added additional screening by running an applicant's name through other FBI files and databases to determine whether or not there was a match. That is, whether or not an applicant's name appeared in any file or database under any circumstances. Maybe just an association with somebody else's whose name was in that database. Naturalization. Naturalization is not discretionary. If the applicant has complied with all the requirements, USCIS must grant the application. In addition to the specific 120-day deadline for adjudication application after the examination, 8 U.S.C. subsection 1571B states, quote, "It is the sense of Congress that the processing of an immigration application should be completed not later than 180 days after the initial date of filing the application," end quote. This provision, along with other statutory provisions, makes clear Congress's intent to eliminate persistent backlogs in the processing of immigration applications. Congress has defined backlogs as, quote, "the period of time in excess of the 180 days that such application has been pending before the USCIS," end quote. These provisions make clear that USCIS is generally expected to process and adjudicate a naturalization application within 180 days, not delay it for years and eventually deny. The naturalization process also cannot be prolonged indefinitely. USCIS must make a final determination on every naturalization application either at the time of the examination or at the latest within 120 days after the date of the examination. And the examination is usually referred to as a civics test. CARRP, USCIS's secret national security policy. CARRP procedures govern all stages of the processing and adjudication of an immigration application from the moment the application is filed to the moment it is decided, if it ever does get decided. The case will remain on a CARRP track so long as the agency continues to believe that the person poses a, quote, national security concern, end quote, or is otherwise instructed by the FBI to treat them as a concern. CARRP procedures govern all stages of the processing and adjudication of an immigration application from the moment the application is filed to the moment it is decided. It applies to all applications or petitions to USCIS that request immigrant or non-immigrant status, making CARRP inapplicable to only a handful of applications handled by USCIS. CARRP's process for adjudicating applications proceeds in 4 basic stages. Stage 1 involves identifying whether a national security concern exists in an individual case. If so, USCIS will move the case from routine adjudication, and we'll hear about something routine later on, track to a CARRP track, and every aspect of the case will be handled in accordance with the CARRP policy. The case will remain on a CARRP track so long as the agency continues to believe that the person poses a national security concern or is otherwise instructed by the FBI to treat them as a concern. Stage 2 and 3 are investigative stages aimed at finding a reason to deny an application. And stage 4 is the adjudicative stage, at which point a decision must be rendered. Stage 1, identifying national security concerns, catching far too many in the net. USCIS screens every application for an immigration benefit at the outset through a series of securities and background checks to determine if any possible national security concern is present. CARRP defines a national security concern as an individual or organization that has been determined to have an articulable link. I couldn't even look that word up in the dictionary, it didn't exist. Articulable link to prior current, or planned involvement in or association with an activity, individual, or organization described in the Security and Terrorism sections of the Immigration and Nationality Act. The terms link and association with are not further defined, thus leaving this definition extremely vague. Moreover, while the policy suggests that officers should use the activities, individuals, and organizations described in the Security and Terrorism sections of the Act as exemplars of indicators of a national security concern, it also makes clear that the facts of the case do not need to satisfy the legal standard used in determining admissibility or removability, a qualification that only further expands the vagueness and breadth of the definition. In order to determine whether an applicant presents a national security concern, USCIS officers are directed to look for indicators that may implicate national security concerns through responses to security checks or other information obtained during the adjudicative process. Security checks are now conducted at the outset of the processing of an application, soon after an individual applies for an immigration benefit. While a number of security checks are performed, the FBI name check appears to be the security check most utilized for identifying indicators of a national security concern. The terrorist watch list is notoriously over-inclusive, containing among its at least 875,000 names, thousands of U.S. residents of Amemsa descent who pose no threat to the security of this country. This over-inclusion arises because the watch list does not require evidence that the listed individuals pose a threat of engaging in any terrorist activity. Nonetheless, once someone's name is on the watch list, the federal government does not provide a meaningful way for that person to contest his placement and have her name removed. The watch list operation is particularly unfair when coupled with CARPP. Even if an applicant's name erroneously appears on the watch list, she or he is also blacklisted from obtaining the immigration benefit that she or he seeks. If USCIS's secret checks reveal that an applicant appears on the terrorist watch list, he or she is thus a KST, a known terrorist, and under CARPP, USCIS will automatically consider that applicant a national security concern. Here they are getting it wrong. Ibrahim Mousavi, a 61-year-old Iranian national, a Muslim, and 35-year lawful resident of the United States. He's waited for 13 years for a decision on his naturalization application, which he filed in 2000. Ibrahim has never been convicted of a crime and has lived a peaceful life in the United States. He believes the government placed his name on the terrorist watch list for reasons unknown to him, because the Border Patrol agents routinely subject him to interrogation at secondary inspection when he enters the United States from overseas trips. These inspections demonstrate that USCIS consider him a KST and that his naturalization application is subject to CARPP, thus explaining the 13-year delay. Samir, a Tunisian national, a practicing Muslim, and 13-year lawful resident of the United States, has been waiting for 3 years for a determination on his naturalization application. He has never been charged or convicted of a crime. Samir is routinely subjected to secondary inspection when he returns to the United States, and he was once denied boarding on a U.S. flight. He is thus likely on the terrorist watch list. As a result, USCIS likely considers him a KST and has put his naturalization application on a CARPP track, explaining the delay and disparate treatment he has experienced in the application process. During his naturalization interview in September 2011, for which USCIS gave him only 1 day's notice, which is not enough. If you have an attorney, you need to have a longer period of time to get all of that prepared. A USCIS agent questioned him extensively about his religious affiliations and ongoing relationships back home in Tunisia, and about how much money he has sent in support of his family. Such questions have no bearing on his eligibility to naturalize. KAST is obviously getting it wrong. You might know some of these people on this list. The following individuals are or were at one time on the terrorist watch list. If any of these individuals were to apply for an immigration benefit, USCIS would have automatically deemed them a national security concern and would delay and ultimately deny their applications under CARPP. Nelson Mandela was listed on the terrorist watch list and needed special permission to enter the United States. Fortunately, Mr. Mandela was removed from the watch list by an act of Congress in 2008, an act of Congress, a solution the average person cannot rely upon. Senator Edward Kennedy learned his name was on the terrorist watch list after suffering repeated delays at the airport security. Removal of his name eventually required him to have a personal conversation with the Secretary of Department of Homeland Security. Again, something the average person would not be able to do. Representative John Lewis, a hero of the civil rights movement, was on the terrorist watch list. Yusuf Islam, formerly known as Cat Stevens, the popular singer, is on the terrorist watch list, and apparently on the more restrictive subset of the watch list known as the no-fly list. How many of you remember Cat Stevens?
Peace Train.
Peace Train, absolutely, Peace Train.
Very subversive.
Here's a quote from Reem Muhana. I've lived in the United States 25 years, more than I've lived in any other place. I feel the U.S. is my home, and now you are telling me that my citizenship is denied because I donated to an organization? The lady in the interview was asking me, Reem, you are a smart lady. You have a master's degree in engineering. How come you didn't know at the time when you were giving money to the organization that it was going to end up being a terrorist organization? I told her, well, I'm not smarter than the U.S. government. Why would you expect me to know that before the government itself found out? In the upper left-hand corner, Tariq Hamdi, he donated money to charities. He's been CARPPed. Ibrahim Mosavi travels to see family. He's been CARPPed. Mahdi Asghari has the suspicious former classmate. He's been CARPPed. So they're looking at family members or close associates. They're looking at indicators that are obviously vague and overbroad, and therefore necessarily capture individuals who pose no threat to the national security at all. This is Zuhair Mahmoud. He's an IT professional. He's been CARPPed. And I don't know if you can tell it from here, but he is, I read somewhere where he's blind, legally blind. The policy effectively directs officers to find national security concerns simply because an applicant is from a given country, again, perceived Muslim or believed to be Muslim or thought to be possibly Muslim. Finally, officers are directed to examine the results of security checks such as the FBI name check, the FBI fingerprint or NCIC criminal history check, the OBIM and ident checks, and TECS and blah, 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 and all those other, to determine whether any indicators of a national security concern are present. Among these security checks the use of the FBI name check is perhaps the most troubling because it is most likely to have a dragnet effect, leading USCIS to erroneously label a person a national security concern without any legitimate basis to do so. CARPP states if the results of the FBI name check are positive, meaning the applicant's name is somehow mentioned in a file somewhere, and the result relates to certain types of national security law enforcement investigations, such as terrorism-related investigations, then they are indicators of a national security concern. Notably, an individual applicant may receive a positive name check from merely being referenced, i.e. mentioned in a file, regardless of whether he or she was the suspect of the investigation. In this way, witnesses, family members, and even victims of crimes, as well as individuals with the same or similar sounding names as people in the FBI file, may receive a positive hit in the FBI name check. Among these security checks, the use of the FBI name check is perhaps the most troubling because it is most likely to have a dragnet effect. CARPP in practice. This is Ahmed Osman Hassan. He's a Somali refugee who spent 14 years of his childhood in a refugee camp in Kenya before resettling in the United States in 2004 with the help of the United Nations High Commissioner for Refugees. Soon after applying for his green card in 2006, police looking for a suspect with similar features mistakenly arrested Ahmed. Despite his release, the FBI file created in his name likely led his application to be subject to CARPP, resulting in USCIS's multi-year delay in processing his green card application and ultimately the FBI targeting him as a potential informant. Between 2009 and 2010, the FBI repeatedly interfered in Ahmed's life to question him on his religious practices and access to other Somali Muslims in his community, promising immigration assistance to him and his family in exchange for information. When Ahmed eventually tired of the anxiety-provoking calls and visits by the FBI, however, and exercised his right to decline additional questions, USCIS, likely at the behest of the FBI, immediately denied Ahmed's green card application and terminated his refugee status. Looking for reasons to deny. Once a national security concern has been identified, USCIS officers are directed under CARPP to conduct a thorough review of the record associated with the application or petition to determine if the individual is eligible for the benefit sought, i.e. conduct an eligibility assessment. Notably, the purpose of the eligibility assessment is to ensure that valuable time and resources are not unnecessarily expended externally vetting a case. The external vetting is the Section 3. The first one is Section 2. With a record owner when the individual is otherwise ineligible for the benefit sought. When this is the case, the application or petition may be denied on any legally sufficient grounds. In other words, at this stage of the CARPP process, officers scrutinize the application or petition far more than they would for a routine adjudication to find any basis upon which they can deny the application in order to avoid spending time and resources vetting the case. CARPP training documents specifically instruct officers on what factors to assess to determine whether they can come up with a reason to deny. The instructions are specifically geared toward finding a basis to deny an application on false testimony grounds or failure to prosecute an application. Failure to prosecute means like just following through on your application. Sometimes they say you failed to prosecute your application, therefore you've just let it go. You just let it go. Officers are instructed to document an eligibility assessment by creating a complete timeline of the person's immigration history, to create a detailed summary and assessment of all the eligibility factors, to conduct a thorough fraud assessment, and to review whether there are any ineligibility factors affecting the previous underlying benefit. Officers are encouraged to carefully review names, addresses listed, marriage history, travel history, and other sources to detect discrepancies and possible evidence of fraud. They are further instructed to look at open source information and tax returns to find evidence of discrepancies on the application that could indicate fraud. At this stage of CARPP process, officers scrutinize the application to find any basis upon which they can deny the application. External vetting is similar to internal vetting in that its purpose is to vet the national security concern and to look for a reason to deny the application. And then they're looking for more reasons to deny. During external vetting, a USCIS officer must confirm the existence of the national security concern with the record owner of the information that created the concern and obtain additional information from that agency regarding the nature of the concern and its relevance to the individual. The officer is also instructed to collect additional information from that agency to support an eligibility determination and removability. If there is no record owner because an officer identified the national security concern through interactions with the applicant or other means, then external vetting is not required. All roads lead to denial. If after external vetting the national security concern remains, officers are instructed to evaluate whether the results of the vetting have any relevance to adjudication and seek to obtain any other additional information, such as through an RFE, a request for evidence, an interview, or administrative site visit that could provide a basis to deny the application. They are instructed to thoroughly document an eligibility determination and to document and pursue facts that would support removal, rescission, termination, or revocation of the person's underlying immigration benefit. All paths for a case labeled a national security concern lead USCIS to find a reason to deny the application. CARPP in practice again. Jamil Haddad is a Palestinian national and practicing Muslim who moved to the United States with his Palestinian American wife 8 years ago with conditional permanent residency status. He filed an I-751 petition to remove the conditions in 2007 as required, but has been repeatedly told that his petition remains pending security checks and is thus forced to file costly extensions every year. So the I-751, with all petitions, there's a lot of money involved, and so it has a time limit. So every time he has to file an extension, he has to file more money. The one thing that USCIS immigration has figured out is that immigration is a really good moneymaker. Every time they turn around, they're asking for money. Three years ago, Jamil tried to naturalize. Although he passed his interview, that's the civic examination, he was again told that USCIS could not adjudicate his application before the resolution of his I-751. Despite this, he has yet to be afforded the opportunity to interview on the I-751, to which he is entitled. Jamil is routinely referred to secondary inspection when he travels, indicating that he is on the watch list, and in 2010, U.S. Customs and Border Protection held him and his family at John F. Kennedy International Airport for 14 hours without explanation. Jamil is likely considered a KST, and it seems that as long as his name remains in the system and there is no cause for denial or deportation, USCIS will continue to indefinitely hold his application in abeyance. Yassine Bamamou is one of a number of Arabic-speaking immigrants who joined the U.S. Army as interpreters during the Iraq War through a program known as 09 Lima, which offered expedited naturalization and other benefits to enlistees in exchange for their service. Specialist Bamamou, who already held a valid green card when he enlisted, hoped to build a career in law enforcement after his service. As soon as he applied to naturalize in 2009, however, USCIS received a request from the Army to place his application in abeyance pending an investigation that was later dropped and proven to be entirely unfounded. Ignoring official letters from the Army clearing his name, USCIS continued to question him on the debunked investigation and prevented his application from moving forward until 2012. Despite his innocence, Specialist Bamamou's name was also never removed from the government's watch list, and as a result, he has been barred not only from serving with the DC National Guard as he had planned, but prevented from gaining other employment in the security sector. So these kind of denials costly affect, not only cost people monetarily, but it really costs them in their job, in their work related areas. If they can't get the jobs that they're looking for in Yassine in security or other type of things like that. Deportation is encouraged. If the agency ultimately finds grounds to deny, the policy directs officers to also look for grounds to support deportation and to coordinate with Immigration and Customs Enforcement, which is ICE, to initiate removal proceedings by serving a notice to appear in immigration court on the applicant. Thus, the policy does not stop at merely finding pretextual grounds to deny naturalization, but goes even further to encourage actual deportation with all of the concomitant hardships, including the separation of entire families. An officer who denies a benefit based on non-KST concern is required to enter a record into a database, TECS, for future reference by law enforcement, presumably creating a record for the use of other federal agencies, indicating that the individual was deemed to have a national security concern. Similarly, non-KST concern cases that are approved must also be documented in Fraud Detection and National Security Unit, FDNS, databases to reflect that the national security concern was not resolved. The Customs and Border Patrol has control of the TECS database. So anytime you're going in and out of the borders, your name is run through that list. That's what got us held up in Blaine, Washington for over 6 hours a number of years ago on our return from Canada, from Vancouver, BC. And we've never been back to Canada since. Through CARPP, USCIS has sought to circumvent Congress, which has sole authority under the Constitution to establish a uniform rule of naturalization by establishing its own set of rules for adjudication. And again, those are immoral, unethical, illegal, and unconstitutional. The top here shows a question and answer period on the deposition of USCIS witness officer Robert Osuna. The question: how does the fact that USCIS considered him, somebody they were talking about, a national security concern affect whether Mr. Hamdi is eligible for naturalization? Answer: well, it doesn't make him statutorily ineligible, But because it is he still has a national security concern. It affects whether or not we can approve him. Question, okay, and why does it affect whether or not you can approve him? Answer, because because there's still a national security concern. Question, and although that doesn't make him ineligible statutorily, how does it make him ineligible otherwise? Answer, well, until that national security concern is resolved, he won't get approval. Question, and how does that come from a body of law or policy? Answer, well, it comes from, yes, it does. Question, what body of law or policy does that come from? Answer, that comes from the CARPP policy. Illegal. The impact of CARPP: discrimination, delay, and denial. Although there are numerous legal and policy problems with CARPP, 3 problems in particular raise the greatest concerns. First, CARPP disproportionately impacts law-abiding immigrants from AMEMSA communities, Arab, Middle Eastern, Muslim, South Asian communities, mislabeling them national security concerns based on arbitrary and discriminatory criteria. Second, it mandates inordinate delays in the processing and adjudication of immigration applications, thereby leaving law-abiding aspiring Americans waiting for years in limbo while their applications remain unadjudicated. And third, it creates secret exclusions to immigration benefits not authorized by law, resulting in pretextual and often unfounded denials of such benefits. Yet despite these serious consequences, applicants are never told that their applications have been subjected to CARPP's processing rules, and they have no opportunity to contest that classification. CARPP disproportionately impacts law-abiding AMEMSA immigrants and label them as NS, national security concern. They do this via the terrorist watch list and FBI name check, through national origin and associational criteria, and equating Islam with terrorism. CARPP mandates endless delays in violation of the immigration and naturalization laws. CARPP subjects applicants to inordinate delays in the processing and adjudication of their applications. Given that CARPP imposes no deadlines for any of these processes, and that it explicitly forbids the approval of an application, even when the applicant is statutorily eligible, unless its dictates have been satisfied, CARPP produces indefinite delays for people awaiting naturalization. Aspiring citizens are forced to choose between endlessly waiting for movement on their applications and filing mandamus lawsuits against the country to which they wish to swear allegiance. There's a little bit of weirdness right there. They have to file a lawsuit against the country they want to swear allegiance to, at great burden and expense. CARPP expressly directs officers to flout the statutory rules by purporting to authorize them to delay and hold cases in abeyance without limitation. This is Hassan Razmara. Just because I did not sign an agreement with the FBI to spy on my community, I've not received my citizenship, and I lost a lot of job opportunities. I am an engineer, and many employers only hire U.S. citizens. I've struggled to afford my family's expenses, rent, and credit card payments. During the last 2 years, I went to the immigration building, but nothing has changed. They just repeat that my application is pending further, quote, background checks, end quote. This chart shows a delay in naturalization cases. The very across the top shows the number of years that some of these applicants have been waiting. The very top bar is the statutory wait limit. That's the about the 180 days. And so you can see some of these have gone out to 9, 10, and 13 years. And I'm sorry, I cannot read. Just one moment. I'll find it in my book. The third one from the top, Mahdi Asghari. He's waited 3 years. He was granted naturalization by USCIS. The next one down, Jamal Atalia, granted naturalization by district court. Yassine Bamamou, he was the one in the U.S. military, granted naturalization by USCIS. Samir Ben Hassin, application is still pending after 3 years. Mursad Hajro, after 8 years, almost 9 years, granted naturalization by district court. Mohammed Hamdan, after 5 years, granted naturalization by USCIS on administrative approval. That's where the officers are not allowed to make the judgment. They have to give it to their superiors. Tariq Hamdi, 11 years, granted naturalization by district court. Hassam Khalil, application is still pending. Zahir Mahmoud, granted naturalization by district court. Ibrahim Masavi, application is still pending. Reem Ahmed Mohana, application still pending. And Hassan Razmara, application still pending. CARPP creates secret exclusions not authorized by law and mandates pretextual denials. CARPP bars applicants deemed to be national security concerns from obtaining immigration, even in cases where they are statutorily eligible. They use secret exclusions. CARPP has created extra statutory exclusions that find no support in existing law. To make matters worse, these determinations are largely unreviewable because USCIS does not tell applicants that their applications have been subject to CARPP or give them any opportunity to contest that designation. They use pretextual denials. CARPP instructs officers to look at certain eligibility factors to find statutory denial. Some examples of that is anything that can be construed as false testimony, or anything that can be construed as failure to prosecute an application. USCIS has effectively created its own set of criteria for who should and should not receive citizenship, entrusting itself with the authority to make determinations based on its own policy dictates rather than what the Constitution requires. USCIS often claims in CARPP cases that an applicant failed to disclose an association or membership with an Islamic organization, whether a charity, an organization, or a mosque. But unsurprisingly, USCIS does not make the same claims about Christian, Jewish, or secular organizations. USCIS heavily relies on false testimony as grounds to deny naturalization applications subject to CARPP. Because the policy requires officers to find a basis to deny an application subject to CARPP, the false testimony grounds for lacking the requisite good moral character is the easiest statutory ground to assert because it is relatively amorphous. By giving itself the authority to deny applications based on secret criteria that it never discloses, USCIS denies applicants the fairness they are due under the Fifth Amendment to the U.S. Constitution and applicable immigration regulations. If we ask our newest citizens to take a meaningful oath to uphold, quote, the principles of the U.S. Constitution, end quote, and be, quote, well disposed to the good order and happiness of the United States, end quote, we must ask the very agency that adjudicates applications for that oath to do the same. In some, CARPP has mandated delays in processing and ultimately denials in many cases involving AMEMSA immigrants, even though the applicants are lawfully entitled to the benefits they seek. And this is, I think, Tarek, who's finally got his citizenship. And he got it just in time to vote in 2012. So a couple of days ago, just literally a few days ago, somebody sent me an email, and these are some presidential quotes on Islam and Muslims. Barack Obama, quote, "Islam has always been a part of America's story, and since our founding, American Muslims have enriched the United States," end quote. And another quote, "Islam has demonstrated through words and deeds the possibilities of religious tolerance and racial equality," end quote. Quote, "Islamic culture has given us majestic arches and soaring spires, timeless poetry and cherished music, elegant calligraphy and places of peaceful contemplation," end quote. George W. Bush, quote, "Here in the United States, our Muslim citizens are making many contributions in business, science, and law, medicine and education, and in other fields. They are upholding our nation's ideals of liberty and justice in a world at peace," end quote. Quote, "Islam inspires countless individuals to lead lives of honesty, integrity, and morality," end quote. Bill Clinton, quote, "Americans know the traditional values of Islam, devotion to faith, and good works to family and society are in harmony with the best of American ideals," end quote. George H.W. Bush, quote, "And I'm not a student of religion, but I don't find anything in what the principal teachings of Islam that put us in contradiction at all. In fact, the principles are the same as what? We have a diverse religious culture, but it's kindness, it's be good to your neighbor, it's love, and it's take care of children. It's all these things that, so there's no anti-Islam," end quote. Jimmy Carter, quote, "From the beginning, the United States has enjoyed close and valued ties with the Muslim world," end quote. Quote, "We have the deepest respect and reverence for Islam and all who share the faith of Islam," end quote. Quote, "On the basis of both values and interests, the natural relationship between Islam and the United States is one of friendship," end quote. Gerald Ford, quote, "For nearly 200 years, our nation has derived its strength from the diversity of its people and of their beliefs. That strength has been greatly enhanced by the Islamic religious heritage," end quote. And Dwight D. Eisenhower, quote, "Civilization owes to the Islamic world some of its most important tools and achievements. The Muslim genius has added much to the culture of all peoples," end quote. And way back in 1796, John Adams, quote, "The United States of America has in itself no character of enmity against the laws, religion, or tranquility of Muslims," end quote. So I want you to think about George Orwell's 1984 and Aldous Huxley's Brave New World. How many have read those books, or at least one of them? Yeah. What glimpses of the future did those books show us? And how much of that has come to be true? Can you imagine that CARPP is the precursor to what is ahead for all of us? And remember the poem at the very beginning? What additional lines will we add to his poem? If we don't speak up for others, who will be left to speak for us? First they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionist, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for the Native Americans, and I did not speak out because I was not a Native American. Then they came for the Negro, and I did not speak out because I was not Negro. Then they came for the Irish, and I did not speak out because I was not Irish. Then they came for the Japanese, and I did not speak out because I was not Japanese. Then they came for the Hispanic, and I did not speak out because I was not Hispanic. Then they came for the alien, and I did not speak out because I thought I wasn't alien. Then they came for the Muslims, and I did not speak out because I was not Muslim. Then they came for me, and there was no one left to speak for me. Julian Assange has said, quote, that what happens to the Muslim community, sure enough, sooner or later, happens to the rest of us.